Welcome, everyone. I'm Lori Nelson, the Alumni Relations Director at the University of Utah S.J. Quinney College of Law, and I'm so glad you're able to join us today. We have a wonderful program for you today, but before we get started, let me go through some housekeeping matters. First of all, pursuant to Utah Supreme Court rules for CLE, you have to stay on for the entire hour. If for some reason you bounce off and sign in using a different ID, for instance, you are using an email, but then you bounce off and have to sign in using your phone, please email me at lori.nelson@law.utah.edu so I can make sure you get credit for the time that you're on. Also, at the end, we're going to have time for questions. Please use the Q&A feature and not the chat feature, and we'll monitor those questions. If you see a question that is similar to a question you're going to ask, you can vote it up and it will go to the top of the queue. Last, we'd like to acknowledge that the land on which the University of Utah sits is named for the Ute tribe, is a traditional and ancestral homeland of the Shoshone, Paiute, Goshute, and Ute tribes. The University of Utah recognizes and respects the enduring relationship that exists between many Indigenous people and their traditional homelands. Now, it's my pleasure to introduce the speakers for today. We have Christina Jepson and Mike O'Brien, who are now at the same law firm, Parsons Behle, and I'd like to start this program by turning it over to Mike.
Thank you, Lori. Good afternoon, everybody. I am thrilled and delighted to be with you, and even more so to have the opportunity to present with the bright and engaging Christina Jepson, my law partner for the last 6 months and hopefully for many, many more years into the future. As some of you may know, a few months ago, I switched from Jones Waldo, a firm I loved, to Parsons, Behle, and Latimer, a firm that I equally love now as well. I appreciate the opportunity to be here. Christina and I don't do the usual New Year's stuff, where we worry about making resolutions about weight or budgeting. Instead, we think about employment law and how we can figure out what's going to happen in the new year and how we can help our clients deal with those intriguing issues that may pop up in 2023. So we put our heads together and came up with what we think are the top 10 hot employment law topics for the coming year. And we're just going to go back and forth covering those 10 in a very high level, snappy presentation, sort of to raise your consciousness about them, get you thinking about them too, so that you can help your clients with those issues if you're confronted with them. As Lori mentioned, we're happy to hear questions and try to answer them at the end. So with that, I will jump right in. Again, we have to give our usual disclaimer. This is not legal advice. It's good and useful information, but it's not and shouldn't be viewed as a substitute for getting legal counsel on any of the issues about which we are talking. So the first issue is sort of a breaking news sort of thing. The Federal Trade Commission has issued a proposed rule that would ban non-compete agreements nationally, which is, when I saw this, I just sent out an email to our group and said, wow, I thought it was a pretty big development. In 2021, President Biden signed an executive order asking the FTC to look into this, but nothing happened for about a year and a half until just about a week ago. And on January 5th, 2023, the FTC published its notice of proposed rulemaking to ban non-competes. And in a nutshell, the rule would make it illegal for an employer to enter into a non-compete, to maintain a non-compete with a worker. And by the way, worker means both employee and independent contractor. And interestingly enough, on that third bullet point, it would be illegal to represent to a worker that the worker is subject to a non-compete. I thought that was a really intriguing third point to add to the proposed rule. It's retroactive as well. It would require employers to rescind existing non-competes and actively inform workers that they are no longer in effect. One exception would be that it doesn't apply to other types of employment restrictions, such as non-disclosure agreements. However, if they're written broadly enough where they could function as a non-compete, then in fact, the new proposed rule would apply to them as well. Here's the definition they give of the non-compete: a contractual term between an employer and an employee that prevents the worker from seeking or accepting employment with a person or operating a business. It doesn't apply to a non-compete that's put in place by someone selling a business if that person is a substantial owner. But it does apply to what are referred to in the rule as de facto non-competes. And there's a functional test as to whether something which isn't even called a non-compete is in fact a non-compete clause. And that language, again, there on the screen says that the functional test is if it has the effect of prohibiting the worker from seeking or accepting employment with a person or operating a business after the conclusion of the worker's employment with the employer. And then it gives you a list of proposed de facto non-competes. The first bullet point there is a rather broad one. The second one is really interesting to me because it goes so far to say that if there's an agreement between an employer and the worker where the employee has to pay back training costs if they leave employment within a specified period, that would be viewed as a de facto non-compete as well and would be illegal under the new proposed rule. Unanswered in all of this is whether a non-solicitation clause is still valid. I think as you sort of analyze this in your head, you could see how potentially, depending on how that non-solicitation clause is written, that it could also be a de facto non-compete. So maybe you like this, maybe you don't, maybe you don't care. Anything is appropriate in all of those areas, but if you do like it, or if you don't like it, tell the FTC. You have 60 days until early March of 2023 to give comment. There's a link there, a website address as to how you can do it. And intriguingly, the FTC has said what it's particularly interested in hearing about. And those are those 3 bullet points, whether franchisees should be covered by the rule, whether senior executives should be exempted from the rule, or whether there should be a difference between how low and high wage workers are treated. So intriguing new hot development to get us all started here. Well, whether or not non-competes will exist in 2023 or thereafter. Next hot issue, Christina, I think there's some new federal laws you want to talk about. Am I right?
You're right. Thank you. I'm also so happy to be presenting today with Michael O'Brien, my new partner, and as you probably all know, he's as good as it gets at employment law. I also want to give a shout out to our partner who's not here, Mark Tolman, who actually prepared a lot of these slides. So yes, a little unusual. We have some new federal laws, which we don't get a lot of. They're kind of rare, but we have some. And if we look at the first slide, the first 2 I want to talk about are 2 dealing, with pregnancy and breastfeeding. The first one is the Pregnant Workers Fairness Act, and the second one is Providing Urgent Maternal Protections for Nursing Mothers Act. Right? They always have to have these strange names, but it's the PUMP Act, which is pretty easy to remember. So let's look at what these mean. So first of all, it's important to know always in employment law when these apply to a client's business. So the first one, the Pregnant Workers Act, applies if there are 15 employees. If a company has at least 15 employees, they're required to provide accommodations. And probably many of you are familiar with that in terms of, the ADA. And those have to be provided in terms of pregnancy, childbirth, and related medical conditions. So some of the accommodations that might be very common with pregnancy, light duty, water bottle, a stool, if someone's working at a counter, for example, and needs to sit more frequently, more frequent restroom breaks, those sort of things are the things we'd be looking at. Okay, so let's go to the next slide. As I mentioned before, the accommodations under the Pregnant Workers Act is very similar to the ADA. So similar sort of analysis, an employee wanting an accommodation, the employer looking at the accommodation and seeing if it's something that they can make happen. So just like under the ADA, you would be asking, is this person asking for something that would eliminate their essential job functions? Because of course you don't have to do that if you're an employer. So for example, if someone wants light duty and they are a warehouse worker who does very strenuous work all the time, and you really can't eliminate those job functions and accommodate them, that might be an argument that it can't be allowed. It's hard to imagine a situation where allowing someone more frequent restroom breaks or, some extra water would eliminate their essential job functions, but it depends on the job. Also, the employer also always has the opportunity to try to argue that it would be an undue hardship, whatever accommodation is being requested. And they can also argue that there's some sort of alternative accommodation that would also work and would be better for the employer. So very similar to the ADA analysis. And that's what we're going to be looking at with this new law. Okay, the next slide. It's also important to know that the PUMP Act amends the Fair Labor Standards Act, and that just went into effect, but really will not be enforced until April. And knowing that it is part of the Fair Labor Standards Act should alert you that there's a private right of action if there's a violation, with all the sort of normal remedies that a plaintiff could get under the Fair Labor Standards Act. Now, under the PUMP Act, there's two basic things an employer is required to provide. They're required to provide break time so that a new mother can express breast milk, and they're required to provide a private place so that she can do that. And no, that's not a bathroom. And this should already sound pretty familiar, because if we look at the new slide, this has been Utah law for quite a while. So if you're in Utah, we've already been doing this. You also need to know, I'm sorry, can you just go back one, Michael? So the break time, you do have to provide the break time. It does not have to be paid. It doesn't mean you can't pay it if you would like to, which would be a good thing to do, but it can be unpaid. And again, there's, arguments about undue hardship that an employer could make. I think it would be pretty rare circumstances that they would be successful on that. Okay, next slide. So like I mentioned, this has already been Utah law for quite a while, several years. In Utah, specifically, an employer cannot require a doctor's notes for very straightforward accommodations like restroom, food, water breaks. Those should be just automatically accepted without a doctor's note. Also, under Utah law, you have to have some sort of written policy on this topic of having time and space for a mother to pump. So that could either be a handbook, it could be a separate policy, it could be a poster, but it needs to be some sort of written policy. So if your clients don't have that in their handbooks, it's something they're going to want to look at. All right, next. The other thing that Congress has been up to is really the whole area of the Me Too. Ever since Me Too, there's been a lot of legislation trying to limit how much an employer can protect negotiations, confidentiality, issues like that around sexual assault and sexual harassment. So the newest law is called the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. So just like it sounds, it's going to limit the employer's ability to have arbitration clauses for those types of claims. And if we look at the next slide, we'll get a little more into the specifics. So specifically, you can't have these sort of agreements if they're pre-dispute. So after a dispute arises, for example, in a settlement of a matter like that, you could have an arbitration clause. But pre-dispute, so like in an employment agreement, an arbitration agreement that's entered into as part of starting employment or during employment, those arbitration agreements cannot apply to claims of sexual assault or sexual harassment. So one thing I've been doing is going back and looking at clients' arbitration agreements and excluding those types of claims from their arbitration agreements so that there isn't an argument that those are invalid. Because an employee cannot waive their right to a jury trial, a right to participate in a class action in sexual assault or harassment claims. Okay, next slide. That's it. Back to you, Mike.
Great. Thanks, Christina. It is really exciting to have federal laws, new federal laws to talk about and deal with. So that's really an important development. Of course, those federal laws, at least one of the ones that Christina was talking about, will be enforced by the Equal Employment Opportunity Commission, as well as the Utah Anti-Discrimination Division. And both entities are both big players in employment law every year. So it's always good to know what they're up to. And this year, there's breaking news about those laws as well from the courts. Just a couple of days ago, we all here at Parsons read and shared an article with each other about the U.S. Supreme Court asking for input from the U.S. Solicitor General about the scope of the federal anti-discrimination laws. Right now, they apply to what's known as adverse actions that are materially significant or create materially significant disadvantages for employees. But the court has asked whether that should be viewed more broadly so that so-called less serious events that aren't as serious as firings or demotions, for example, things like lateral transfers or paid suspensions, whether those should be the sort of adverse actions that also should allow employees to bring discrimination claims. If that interpretation and understanding of the law is broadened, then that's going to create a whole new set of opportunities for employees to bring claims, for plaintiffs' employment lawyers to advise and protect their clients, and for employment and management side lawyers to talk to their clients about additional areas of risk that they need to properly manage. So this is something you want to watch carefully. Neither of the two cases have been accepted by the court for decision yet. So they're apparently getting input from the Solicitor General as to whether or not they should grant a writ of certiorari for those cases. So watch those closely, because I know Christina and I will be doing that. The EEOC annually issues statistics reports as to what charges are looking like, both specifically protected class by protected class, as well as an overall look. Of course, the EEOC's fiscal year ends at the end of September every year, and then probably 5 to 6 months later, you get stats from what that year looked like. So what you're looking at right now are the stats on a bar chart that we prepared through the end of the fiscal year 2021. We don't have the stats yet for the end of the fiscal year 2022. But you can see it's almost a bit of a bell curve there, that claims peaked about 10 years ago in 2021, 2022. They hit almost 100,000 new claims a year. And since then, they have relatively, almost every year, with a couple of exceptions, I guess, in 2016 and 2015, it's a pretty significant downward trend, so that at the end of fiscal year 2021, there were only 60,000 new claims filed, probably due to the pandemic, right? Probably due to the fact that everything slowed down during the pandemic. I'll be really intrigued, as I know Christina will be as well, to find out what those charges look like in 2022, and more importantly, in 2023. Will they go back up? Will employers have to deal with more of these sorts of claims? Really an interesting issue to watch in the coming year. We also have a bar chart for charges filed in Utah with the Utah Anti-Discrimination and Labor Division. And these have held a little more steady over the past 10 years than the EEOC's up and down. But you can see a little bit of variation here and there as well. But generally, the UALD gets about 500, sometimes more charges every year, new discrimination charges. And what are those charges alleging? We have here a comparison of the EEOC claims, top 5 in 2021, and the top 5 claims brought in Utah in 2021. As you can see, retaliation leads the field, both in the Utah agency and with the federal agency. At least half, sometimes more, of the claims brought have a retaliation claim associated with them. That's followed very quickly by disability on a national level and on a Utah level, and then a little bit of variation after that. At the federal level, race, sex, and age are the next 3 most frequently asserted categories. And in Utah, it's sex, age, and race. But all the same 5 ones that the federal government is dealing with are very, very common here in Utah as well. Of course, the EEOC isn't the only agency that regulates employment law. Christina, what has the National Labor Relations Board been up to?
So many of you probably know the NLRB, the National Labor Relations Board. And if we look at the next slide, one of the really important things to understand, this kind of goes with what Mike was talking about as well, is the executive branch, the president, gets to name a lot of people in the administrative agencies. And when the president names different people to those agencies, it changes how they enforce the laws and the things how they interpret the law, and the emphases they make. So that's the same with the National Labor Relations Board. Because President Biden is president now, he has a very pro-labor agenda, and he has named Jennifer Abruzzo as general counsel of the NLRB. And in that position, she is pushing the pro-labor agenda. And these are some of the things that she is going to be focusing on. Handbook rules, which have been pretty exciting for a number of years now, whether certain handbook rules, like a rule that seems as simple to someone who's on management side most of the time, like Mike and I, a rule that says, be kind and considerate to other employees, might be struck down as being influencing or impacting an employee's right to exercise their Section 7 rights to work together to change their workplace. So handbook rules are going to be an issue. Confidentiality provisions in handbooks and separation agreements and arbitration agreements, those are going to be on the table again. And also whether an employee can use the email system for unionizing activities, which, many employers don't want them doing, and employees generally want that to be available. So that's a big issue as well. And then also independent contractor status, which is something Mike is going to talk about in a minute, so I won't get too much into that. But those are just a few of the things that are going to be on the NLRB's mind. So just to take one thing, for example, when talking about Section 7 rights, these are the employees' rights under the National Labor Relations Act to, engage in concerted activity with each other to complain about working conditions, change working conditions. Under the Trump administration, it was a stricter rule. An employee could only show that, that their Section 7 rights were impacted if they met a couple of criteria that were very pro-management. Under President Obama, who was more pro-labor, it was a lot easier rule for the employee to show that their rights were being violated. They just had to show that the employee could reasonably construe the language of the handbook or the policy or whatever is at issue to impact their right to concerted activity. So that's just one example of how different administrations have different ways of looking at things. So, we had the Trump rule, we had the Obama rule, and if we go to the next slide, what's happening now is the National Labor Relations Board is asking for input on that rule again. Specifically in this Stericycle case, the National Labor Relations Board invited the parties and invited anyone else, any other amicus who wants to present a brief about how that rule should stay the same or change, that being the Trump era rule about Section 7 rights. They want input about that. And in particular, they want to know if it should be changed, probably back more like the Obama rule, to better ensure that employees' economic dependence is accounted for, and that there's a proper balance between the rights of employees and employers. So, just like some of these other rules that we've talked about, like the FTC proposals, this has not gone into effect yet. They're asking for input. So if you want to be an amicus and file a brief, you can go ahead and do that. All right, next slide. This final slide on this section, just wanted to mention, in Utah, if you're in Utah, we have always been fairly immune to union activity. There's a pretty low union participation rate in unionization in Utah, but that is changing a little bit. I'm sure you've all noticed the news about Starbucks, because Starbucks employees all across the country are unionizing, but they are doing that specifically in Utah, kind of in my neck of the woods, Cottonwood Heights and Salt Lake City. Places I drive through all the time because I have a 13-year-old daughter who's addicted to Starbucks. In fact, for a long time, I had to keep dollar bills in my car because you couldn't tip on your credit card at Starbucks. And I always thought that might be one of the reasons the employees were trying to unionize, because that makes a big difference in their pay. But anyway, we're seeing unionization go up in Utah. We're seeing it go up across the country. And so the National Labor Relations Boards and the rules are going to have a lot of impact on employers. All right, back to you, Mike.
Thanks, Christina. Christina mentioned that the National Labor Relations Board was looking at independent contractor issues. Well, the Department of Labor, U.S. Department of Labor, is doing that too. And in fact, DOL has issued a new rule that we're going to talk about here in a moment. But essentially, the reason that the Department of Labor gets into this is because they enforced Fair Labor Standards Act, which is a federal law that requires minimum wage and overtime for non-exempt employees, as you all know, of course. So they're interested in that because if someone is being classified or misclassified as an independent contractor, they may not be properly treated under FELSA. They may not be getting minimum wage. They may not be getting overtime. So DOL is very much interested in this. And again, much as Christina mentioned before, this rule tends to bounce around depending on who's in charge of the government. And during the Trump administration, the Trump DOL articulated a rule that was fairly favorable to employers. It focused on two factors: the degree of control over an employee, over a worker, and the opportunity for profit or loss. And if the employer, the business, exercised a significant level of control, and if the employee had little opportunity for, or the worker had little opportunity for profit or loss, they would be properly viewed as an employee and not as an independent contractor. Last October, in the fall, the DOL and the Biden administration, of course, issued a new independent contractor classification guideline that I think could reasonably be viewed as more favorable to the worker, i.e. more difficult to maintain the independent contractor classification. And the proposed rule talks about economic independence as the touchstone, as the key issue in terms of whether or not someone is an employee or an independent contractor. And according to the DOL, that nice quote that we've highlighted in green there, an employee is someone who, as a matter of economic reality, is economically independent on an employer for work, not for income. So an intriguing sort of new element to the analysis that the Biden administration would like to implement. The focus of the rule is whether the worker is in business for themselves rather than the amount of time the worker earns, or whether the worker has other sources of income. Now, traditionally, the IRS and other agencies have thrown other factors into the mix as well, such as degree of control, the skills required, the permanence of the working relationship, whether the work is integral to the company's business, and the opportunity for profit or loss. And so those factors could be considered as well under the new rule. But again, the heart of the rule will be this economic independence rule and analysis. The proposed rule was up for comment until the end of last year. So unlike some of these other hot topics that Christina and I are talking to you about today, the opportunity to speak about this proposed DOL rule has gone by, unfortunately. So sorry for those of you who want to talk about it and aren't able to with the DOL. The final rule is supposed to come out sometime in the first quarter of 2023. So sometime, hopefully before the end of March, we'll know what the DOL is going to be doing on independent contractors. One thing we do know they're doing is that they have joined forces with their friends at the Internal Revenue Service to try to coordinate enforcement activities. On December 14th, 2022, DOL and IRS signed a memorandum of understanding for employment tax referrals. That sounds kind of ominous, doesn't it, Christina? Employment tax referrals. But the MOU states that the goal is to share information to assist in the identification of problems and enforcement related to misclassification. So we think that the bottom line on that is if DOL, for example, finds that an employer has misclassified an employee, then that employer can expect a call from the IRS. Never a happy call to receive. So what about the Utah legislature, Christina? Are they doing anything right now?
Yeah, so what has the Utah legislature been up to, and what will they be up to shortly, right? They're going to be in session soon. We'll find out. So we'll talk a little bit about what came up last year. So the first thing, of course, was COVID vaccines. Big issue, right? And you might be wondering, like, why do we care about this now? Isn't that long gone? Well, who knows? There are new variants. Is COVID going to continue to be a problem or not? It's unclear. But this is sort of how things shook out with the Utah legislature on vaccines. They passed this law, private sector employer vaccine mandates, which talks about when a private employer can or cannot require an employee to get a COVID vaccine. So we're going to show you a really exciting flow chart that will help you understand that. So if you start at the top, we're looking at private employers. And the first sort of premise is that private employers may require employees to be vaccinated against COVID-19. But of course, there's an exception. So if we go follow the arrow, they can require it unless an employee has one of these exceptions. If it would be injurious to their health, as you can imagine, they have to have a doctor's note for that. Or if they have a sincerely held personal belief. It's not just a religious belief, it's a personal belief. So as you can imagine, that exception basically allows anyone to be exempted from the vaccine if they want to, because all they have to say is that they have a sincerely held personal belief that they should not get the vaccine. They can have a religious belief, but they can also just have a personal belief. Or if they provide a doctor's note stating that they have been previously infected with COVID. Is there a time restriction on that, Mike? I wonder, because having been infected one time is, a year ago is not going to make much difference.
Yeah, no, it'd be, with cases rising, it'd be interesting to look at that exact point. Yeah, I think that's a good point.
So employers can require it unless there's an exception, which there's this giant exception any employee could really take advantage of. However, then we go back to the concept that an employer could still require the vaccine, even if someone says they have a sincerely held belief, or even if they say that it would be injurious to their health, if the employer can show basically that it's a requirement for the job. There's a nexus between the requirement and the employee's job. So you can imagine, for example, someone who works in healthcare, they're with patients all the time, and having them vaccinated to protect their patient population would be really important. Also, the employer can show that there's an external requirement for vaccinations. For example, with the healthcare example again, if there's a federal law that requires that hospital to have their employees vaccinated, then they can say, well, despite your sincerely held personal belief, there's a real reason in your job or because of a requirement that we have to live with that you have to get vaccinated. So if that's the case, then you next sort of have to ask, is it possible to reassign that person to somewhere, another job where they don't have to get vaccinated? If they can't be reassigned, then you can terminate them. So that's the analysis that the Utah legislature has landed on. All right, so that's what's going on with COVID vaccines. Let's look what else the legislature has been up to. So the legislature got involved this year, I'm assuming because of economic reasons. They got involved in this issue about, how much an employer has to pay attention to someone's criminal record and whether they can be sued for negligent hiring or negligent supervision if they hire someone with a criminal record. And that can happen, right? An employer doesn't do a criminal check and doesn't realize someone has a criminal record, or they do a criminal check and they hire someone anyway. That person ends up hurting a coworker or a member of the public, and they get sued for negligent hiring. But this new law from the Utah legislature basically says that in certain industries, we'll look at in a minute, they can't be sued for hiring someone with a criminal record if that's the only reason they're being sued, if it's based solely on the fact that the employee has been convicted of an offense. So let's look at the next slide and get a little more detail. So this is the law as of May 2022. Certain employers, just a certain list, are not liable for negligent hiring if that's the only reason they're being sued, if they're being sued solely based on an employee's criminal record. Now, as you can imagine, I look at that and I think that's not that much protection, because usually when someone sues, they're not going to say it's solely someone's criminal record. They're going to say it's their criminal record, and plus maybe they did a couple things at work that should have put the employer on notice that they were potentially violent or whatever the issue is. But at least it's some protection. So if the claim is based solely on the employee's criminal record, they're precluded, they're not liable. And there are two exceptions. Again, if one exception is if hiring that person violated state or federal law. So this time, let's think of maybe about a daycare. Say a daycare is required to do a background check, and by state law or by federal law, and they don't do that, then that would be an exception. Although daycares aren't one of the the industries that are protected. Let's say it's someone on a construction site and they have a federal contract and the federal law requires them to do a background check. Then that would be an exception to this liability protection law. Also, another exception is willful misconduct or gross negligence. So a person suing can always say that it wasn't just negligence, but it was gross negligence. So they would probably be saying more than that this person had a criminal conviction. They would probably be pointing to other things that you should have alerted the employer to not hiring that person. Also, if an employer hires someone and they end up misusing somebody else's funds in that job, so the employer's in charge of some of their customers' funds and the employee misuses those funds, and it turns out that their criminal record showed that they had a history of stealing money or, you know, similar sort of things, then that's also, they're not going to be protected. Now, let's next look at the slide that shows us which industries are specifically protected by this law. Automotive repair, construction, culinary arts, restaurants, basically, manufacturing, oil, gas, and mining, retail sales of goods or services, and transportation. And I think these are areas where the legislature was concerned about employers being able to employ people. There's a labor shortage, as I'm sure you all know. They wanted employers to have some protection and feel like they could employ people, you know, regardless of their criminal background check. So these are the areas that are specifically protected. All right. A couple other bills, I won't go into them in great detail, but the legislature passed a healthcare worker protection amendment, which just increases penalties for a threat of violence or assault in a healthcare facility. And then the next one, SB 63, only applies to public employers, not private employers, but it requires a certain amount of bereavement leave for employees after they lose a child as a result of miscarriage or stillbirth. So that's it for the legislative update. I'll turn it back to you, Mike.
Thanks, Christina. One of the things that our employment group here at Parsons has been fascinated about are what I refer to as the high-profile employees behaving badly syndrome. And we saw some manifestation of that just at the end of last year. So, you know, this hot topic is stripped from the headlines, right? So I stole a screenshot from the Salt Lake Tribune and from the New York Times just to show you what an erudite reader I am of great variety. And the New York Times headline is about Brooklyn Nets star Kyrie Irving and him getting himself into a bit of a controversy over a movie he promoted that was believed to be anti-Semitic, and his unwillingness to back away from those comments after they created a controversy. The other one, closer to home, involved one of the local universities whose athletic director had to resign as part of a controversy. And essentially, you know, here's some more detail in the bullet points as to what happened. You know, Kyrie Irving was suspended for 5 games for a comment he made on his own personal social media post. And eventually he apologized for it, but it took a while to get there. Someone once told me a long time ago, Christina, that if you have to eat crow, it's best to eat it while it's young. So in other words, you know, someone who's said stupid things in his life too, I learned that realizing it right away and apologizing tends to dampen down the controversy. So hopefully Kyrie learned that. But his employer, the Brooklyn Nets, had to intervene for his personal comments because of their concern about the nature of them and deal with it. Same thing happened with the fellow from the university who was caught on video repeating a vulgar and foul joke. And that's a quote from the Salt Lake Tribune. Tribune also quoted part of that joke, which I did not do here because I figure you all can go look it up if you want. And it's a rather distasteful joke. But there was a video clip of it, showed the AD sitting with another individual across from him and talking on his phone and apparently telling the joke to a prominent school booster. So both of these comments arguably are individuals, you know, making comments or telling jokes in their own quote unquote personal capacity through their own personal devices. You know, and you might wonder, what's an employer doing, intervening and dealing with those sorts of possibly off-duty comments. So there's a couple of issues that employers have concerns about with this sort of high-profile misbehavior. Certain people may be so prominent and so high in an organization that they become the brand of the organization. They come to define the organization. So an employer can have legitimate concerns that if that individual is going off-brand, that is something that is not desired for the employer and needs to be dealt with. Those sorts of comments can also be used against the employer in litigation. So and imagine a situation where the Brooklyn Nets are sued for religious discrimination of some kind, and maybe a good, clever plaintiff's lawyer, and there's plenty of them in New York, as there are here in Utah, is going to use the Kyrie Irving comment as an indication of what the culture is at that particular employer's organization. There are risks, of course, in dealing with off-duty conduct. Christina and I get these questions from time to time, and I think we both caution the employer to find a nexus to the workplace, right? There's some hazards in simply, going out there and trying to regulate off-duty conduct all the time in every circumstance. So you want a nexus to the workplace, and you want to be able to show that the employee's off-duty behavior has legitimately damaged the employer's interests. And if you're a public employer, then there's some legitimate concern about the First Amendment and whether or not the public employer is inappropriately impeding the First Amendment rights of the individual employee. So I'll be watching to see more examples of high-profile employees behaving badly in 2023. Given our current life, some of them may be doing so from remote locations, right, Christina?
Yes, I have a question for you, Mike. Do you know how it was that somebody recorded that athletic director making a comment?
It was just somebody who was in the room, right? It was at a restaurant. So, wow. Another example of, in 2023, you're on video all the time, probably, right? Whether it's someone you don't know videotaping you, whether it's a security video, but it was just someone who happened to hear what he was saying, and they caught part of it on video.
Wow, it's just weird to think people are just randomly recording other people. All right, so let's talk about remote workers. If we were doing this 5 years ago, we wouldn't be talking about remote workers. It was a little tiny portion of what was going on. It was a trend, and certainly more and more employees were working remotely, especially in the tech industry. But obviously, everything got turned completely upside down in 2020 with the pandemic. Lots of people went home. Lots of people started working remotely. And now there's a much bigger percentage of employees who work remotely all the time or some of the time. And this has become a really big issue for employers that, we got to think about. So let's go to the first slide. And this is sort of the scenario that you need to be concerned about. This is just from a news article, but this happens all the time. I have clients that call me all the time about this. Mike has clients who call them all the time. And that's this couple who lived in Colorado, a friendly neighbor state, and they worked for 2 different companies, each of them, and they moved to Minnesota. But they didn't tell the employers who they worked for that they had moved. And in fact, when it finally came out that they had moved, they claimed it was just temporary. And then finally, they admitted, they'd sold their house and moved to Minnesota. Now, so why should an employer be concerned about that? Who cares where they live, right? They live in Colorado, they live in Minnesota, you don't care, they're just doing the work. Well, the problem is, if we go to the next slide, in the United States, we're not dealing with one set of laws, we're dealing with 50 set of laws, or 51 if we include the federal government as well. So lots of laws. And if you don't know where your employees work, you don't know what laws you're supposed to be applying. For example, in this scenario, when they lived in Colorado, the employers were probably in Colorado, probably applying Colorado law. But in fact, when the employees moved to Minnesota, Minnesota employment law likely applies. Also, really scary, and Minnesota tax issues apply, which means state employment, state unemployment, state business taxes. You might have to get a business license to even have employees in another state, depending on the state. Of course, it just depends, right? You have to look at it. You have to see if your workers' comp policy that you probably bought in Colorado applies in Minnesota, or if the employer needs to get a different policy in Minnesota. It's a big headache. And so a lot of employers have rules about where people can work. Some of my clients have, we do not hire in these states rules. And Mike, what do you think the number one state is on there? We don't hire in this state.
Just a wild guess, California.
Exactly, California. So let's go to the next slide, because this is the problem, right? If you, for example, have a business in Utah and your employee secretly moves to California, or maybe not so secretly, and now California law applies, there are a lot of employment laws that are very different from Utah that you've got to be aware of. Even Arizona, you think Arizona is very similar to Utah, but they in fact have some mandatory paid leave laws that we don't have in Utah. And so if you have an Arizona employee, because they live there and are working remotely, then you have that problem. And Montana, another very strange state, they're not exactly at will like the other 49 states. In addition, their age discrimination laws apply to people under 40, unlike Utah and federal law that only applies to people 40 and above. So there's just a lot of differences from state to state. Let's go to the next slide. Another biggie, Nevada, as does California, requires daily overtime. So if an employee works more than 8 hours a day, not 40 hours a week, 8 hours a day, they have to be paid overtime. Not something we're familiar with in Utah. Colorado has very strict rules about non-competes that are different from other states. So with remote work, we have to be so concerned about where employees are working and what state laws we have to be concerned about. And think about this, if you have a handbook and maybe you just have employees in Utah and Idaho traditionally, and you have a handbook that covers those two states, and now you have remote workers and they're moving all over the place, you've got to have a handbook that applies to all those different states. So it can be really difficult. So if we look at the next slide, here's just a few suggestions. If if you're concerned about remote employees moving around, first of all, keep track of your employees the best you can. You've got to know where they live because those are the laws that apply. It's really important to require employees to give notice if they're going to move out of state so that you know. You need to check in with employees frequently, right? And this is a hard area because ignorance is not a defense. If they live in another state, that's the law that applies, probably even if you didn't know. But I think you have a much better defense if you required notice and you had a reasonable belief that they were still in the state where you hired them. Okay, let's go to the next slide. Good recommendation to change your policies, change your handbooks in terms of where people are allowed to live, when they're required to give you notice. Also, of course, covering the states where people do live, making sure that in your offer letters, in your remote work agreements, that you have covered where work can be done and when employees have to get permission before moving. And of course, if you're really going to have a rule, for example, no one can work in California, then you got to be ready to let an employee go if they're going to move to California. All right, another fun trend is moonlighting. And that is, you've maybe also heard of this as overemployment. This is a big trend. If you're really bored one day, just Google overemployment. So this is a trend where employees intentionally try to get multiple remote jobs at the same time. So they'll get 2 or 3 jobs. Each of them are supposed to be 40 hours a week. And they work them at the same time during the same hours, from 9 to 5. They just kind of bounce back between all of those jobs and they take in 2 or 3 incomes during the same 40 hours. And if you go online, there's lots of chat rooms that give you advice about how to be overemployed, how to have multiple jobs, and how to not get detected. So if you're an employer, you really need to address this. If we look at the next slide, by doing things like having a policy about whether an employee is allowed to have outside employment and having some restrictions about that. Some really straightforward ones are listed here. For example, they can't have another job if it interferes with your job. If it's during the same hours, it shouldn't be for a competitor. It shouldn't create a conflict of interest. It shouldn't involve using your company information or using your company devices and equipment to work for somebody else. You can imagine when you discover this and you find out, you gave them a laptop and they're working for somebody else. they can't take sick leave with your company and then go work for someone else at the same time. So just some common sense rules about, what people are allowed or not allowed to do to sort of avoid this super secret moonlighting. I mean, obviously there are situations where it's perfectly fine for someone to be a lawyer by day and wait tables at night. Mike does that, right, Mike?
Absolutely.
but there's certainly some situations where you don't want someone sort of secretly being overemployed and not really doing their job. All right, next slide. A couple other things. In the past, talking about employees being able to do remote work because they have a medical issue and, usually an ADA accommodation, it was easier in the past to say, for an employer to say, no, we don't allow people to work at home. But it's much harder for an employer to say that now because we have this experience of people working at home and in many cases doing it very successfully. So when someone wants to work remotely or doesn't want to come back to work and they say it's not because just their preference, but it's because of a medical condition, then that kicks in a couple of laws, right? If you have 50 or more employees, you have to think about FMLA, whether they need time off, and you also have to think about ADA, whether they need an accommodation to, work at home because of their illness. And if we go to the next slide, one of the really big issues in an ADA analysis is whether working on site is essential. If it's an essential function of the job to work on site, then you probably don't have to let them work remotely. But what that means is you've got to get ahead of that by making sure that your job descriptions explain why working on site is an essential function of the job. Being consistent in how you apply that. If you let one person do it and somebody else wants to because of a medical condition, it's going to be very hard to say that that's an essential function of the job. So that's something to start thinking about now that we've just had this experience. And if we go to the next slide, the EEOC has some specific guidance on this where they say, because of the pandemic and because of people working at home, it could be that proved that someone was able to work at home and that might be an appropriate accommodation. So again, it's really important to make a clear record that while you allowed people to work at home because it was a situation with a pandemic, that in regular times you consider it an essential function of the job to work in the office. When I say all of this, I tend to say this from the employer's perspective, and Mike and I are both management side attorneys. So, that caveat that's our bias. Obviously, you would have a very different view on this if you're representing an employee. All right. So yeah, job descriptions are a really big deal. Documenting why telework was a challenge and why it's not something you want to maintain. If it's something you don't want to maintain, that's really what you need to do to sort of head this off. All right. That's it. Back to you, Mike.
Wonderful. Thanks, Christina. And, one of the most significant areas in the exact topic that Christina was just talking about are this new emerging patchwork quilt, I call it, of state paid leave laws. There's many other variations in state law besides issues involving leave, but one of the most significant and challenging one, I might add, deals with paid state leave laws. And you can see, thanks to Standard Insurance, I found a nice patchwork quilt of the US showing various forms of leave required in various states. 4 quick things that you need to know about this. As Christina has explained, you need to follow the local law where the employee lives and works. That's critical. One increasing area of state regulation is paid leave. And that includes our neighbors right here in the Intermountain West. Nevada, Colorado, New Mexico, and Arizona all have various forms of paid leave laws. When you're trying to do an employee handbook, which we've done for several clients within the last few months, one of the most vexing issues to deal with is how do we reconcile all these different statutes that have different requirements about paid leave? And here's the 5 common variances we've come across. The amount of leave, how much paid leave is required. How does it accrue to an individual employee? How can they use it? And what sort of increments, when and how? What can it be used for? Is it sickness only? Is it for sickness of a family member? And when and how does it vest? In other words, can they get paid for it when they leave the organization? So some very, very difficult and vexing issues that you need to pay careful attention to on these issues. We're down to our last topic, and we're going to end on a high note, pun intended. And Christina's going to talk about marijuana and psychedelics in the workplace.
Right. So, I mean, I've been a Utah resident in my entire life. The concept of talking about legal marijuana in Utah just seems so crazy to me. And just a couple of years ago, we were only talking about marijuana, and now we're talking about psychedelics. The world has changed, right? So if we look at the next slide, just a little bit of history. I think this is so interesting. 1915, Utah's the second state to jump on to prohibition and even expressly banned cannabis and marijuana. 2014, though, we now have CBD legalization. 2018, medical cannabis right to try law was passed. 2018, of course, was the big ballot proposition where the electorate just took things into their own hands and passed medical cannabis. And then the Utah legislature followed up with that by putting together a law that basically allowed medical cannabis in Utah to different degrees. All right, so now the law that was passed in Utah is a little confusing because it does require state and local governments in terms of their employees to treat them just as they would employees who are legally using opioids. So an employee might be legally using some sort of opiate painkiller, maybe after surgery or something. And if they're doing that, you have to do an analysis in the workplace, right? If they're an office worker, it's probably not going to be an issue. If they're operating a crane, that's probably an issue, right? So that's the kind of analysis, but you have to treat it that way. And you can't just say, no, we're not hiring you because you're legally using an opioid. And with state and local government employees, the same is true with medical cannabis. But the statute is completely silent about private employers. So it seems that private employers do not have to do that same analysis, that they could just say if someone's using medical cannabis, they're not going to hire them. But we have absolutely no case law about that. So that's kind of where we are. Though I think in terms of the history, I think this is super interesting to just sort of think about. If you told me in the 70s, the 80s, the early 90s that Utah was going to have legal medical marijuana someday, I just wouldn't believe that. But look at just 1996. Not that long ago, when California became the first state to allow medical marijuana, and the rest of the country, nothing was allowed, right? Then we jump forward to 2019, and you can see the dark brown, that's recreational marijuana is then legalized. Medical marijuana legalized in a lot of states, including Utah. And CBD oil, you can kind of see the light tan. There's really just in this one in 2019, just 4 states, including our neighbors in Idaho, who don't have any sort of legalization of these sort of things. All right, let's go to the next one. 2022. Now we're down to 3 states, Idaho and 2. Does anyone know who the rectangle states are? I assume maybe Nebraska and I don't know. Do you know, Mike?
Yeah, I think so. I think that's right.
So we're just down to 3 states who have not either legalized marijuana recreationally, medically, or have not legalized CBD oil. And probably if any of you go to the grocery store or anywhere, you can buy CBD oil, absolutely anywhere. It's just completely changed. So let's go forward. Just like we've been talking with so many topics, the problem for employers is every state is different. You could see in that map, there's certainly over time has been more and more legalization, but some states allow medical, some states allow recreational, some allow CBD, and then each one of those laws is a little different in terms of, what medical conditions qualify. What do you have to do to register or verify that you're allowed to use marijuana? What's the oversight? What's the job protection? We talked about Utah. Right now, it seems to only be for public employees, but some states, they say either nothing about it or they require specifically more protection for employees. So you have to know your state, and you also, the state where your employees are. And again, if they're working remotely and moving around, you got to keep track of that. And you also have to keep track of the law, because you can see every single year this is changing. All right, next slide. In some states have, just go back one more, there you go. So some states have what's called legal off-duty conduct laws, which means employees usually under those laws, and New York is a big example, employees are allowed to do whatever they want, which is legal when they're off duty, and an employer generally can't do anything about it. And as you can imagine, in some of these states, that includes using marijuana if it happens to be legal. Maine has one of the most liberal laws for employers, which says an employer cannot refuse to employ a person who's 21 years or older because they're consuming marijuana outside of work. Now, if they show up high or try to drive your crane high, that's different, but just using it off of work time. So you have to be aware of your state. Okay, next. There's also a lot of different laws in terms of drug testing. So for example, in DC, you're not allowed to test employees prior to an offer of employment. You're not allowed to test them for marijuana. And in Maine, remember our very liberal Maine, you can't do any pre-employment marijuana drug testing as well. And different states have different rules about what's considered impairment at work. And this is the problem. Marijuana stays in your system for a long time. So, for example, they could take a piece of your hair and they might find marijuana in it, but that doesn't mean you're impaired. That might mean that you had it in the last 30 days, which could mean that you used it legally off duty, right? So there's a lot of new rules about what you can consider a positive test and what you can consider impairment if you test someone for marijuana. Because unlike alcohol, which usually if it's in your system is impacting you at that moment, marijuana is different. So drug testing, there's just more scrutiny of that. I guess it's your blood as well, definitely in your hair. And, whether you can fire someone or take other action because they have tested positive is just different in every state. And you've got to look at that. And also, just stay tuned for what the federal government is going to do. Still, technically, marijuana is illegal at the federal level, but it's almost become a joke because it's so legal at a state level. Now, also new is therapeutic psychedelics. Psychedelics, things like psychedelic mushrooms and other psychedelics are starting to become legal as well. Colorado and Oregon, some specific cities have legalized them. And I didn't even know this until I was researching for this presentation, that medical ketamine, which is also psychedelic, is legal in every state. And this is just my own little comment. I was getting a massage the other day. And now when you go get a massage, one of the add-ons you can get is CBD oil when you get a massage. But the place where I got a massage also offered ketamine sessions. You could come in and get a ketamine session. I didn't even know that.
Wow.
And they're not a medical provider. They are, I don't know who administers it. But anyway, this is obviously a very big trend. So stay tuned, stay aware, and make sure you know where your employees are. A lot of people are thinking about what's our need, what's our culture. Some employers are dropping marijuana testing from their pre-employment testing because they're just not going to have employees if they test. If you are going to test and you're going to test it with marijuana, you need to be very specific that what you're testing for and whether you're allowing legally prescribed. You got to be very specific and make sure that you're updating all of your policies and procedures. All right, that's it. Mike, any final words?
No, great job. Great job, Christina. And when we're done, you'll have to give me the address of that place where you can get those massage things down.
Thank you guys so much. I was right when we were doing our run through. I said, yes, it's Friday the 13th, but the only people who are unlucky are the ones who weren't on this program. But we do have a couple questions really quickly, if we could get those addressed. And I will tell you, my naivete says to me, it makes absolutely no sense that the law you would apply is the law where the employee is rather than the law where the employer is, because that is basically a fixed point and the employees can move around. But that being said, one question is, if you have an employee who reports residing in a particular state, but you have reason to believe they're residing in a completely different state, is the employer liable to comply with the law of the state where you believe the employee is residing rather than the state where they say they are residing? And how does that situation affect state payroll tax deductions?
Yeah, so the answer, Mike can tell me if he disagrees, but I would say the employer probably is liable for where that employee lives, because laws our state laws are, most of them are meant to protect the employee. So it matters where the employee is, not where the employer is. And so I'll give you an example. I had a client who had an employee working remotely, and that person moved and they didn't know, but they could tell from the IP address where the person was logging with their computer that that person was probably somewhere else. And they thought that maybe they were just visiting. It turned out they really weren't. So it was the employer's duty to get to the bottom of that and figure it out. And yes, comply with that state's law, and also, figure out what that state requires in terms of payroll and other taxes. Now, some states have some grace periods. If someone is just going to be working in the state for a few weeks, you don't have to pay taxes in that state. Every state, has a different rule about how long counts until they are considered in that state, and you have to comply with the tax laws there. Anything to add to that, Mike?
No, by the way, I'm in Dublin, Ireland right now.
Yeah, we're not even going to get into international. That's a whole nother.
So if you do a remote work agreement with your employee, can you put in a choice of law provision that says the law that we will apply is the law where the employer is?
Well, yes, you can put it in. Will it be effective? I would say probably not. I would think if that got litigated, most states would say the employer and employee cannot agree to choose another state for the law to apply as opposed to where the employee lives. What do you think, Mike?
Completely agree.
Okay, so back to the highlights of the program. If a person tests positive for THC, is an employer allowed to ask if the person has a prescription or permission to use the marijuana?
Do you want to take that, Mike?
Sure. Generally in drug testing, I know under the Utah law, this is true. You want your medical review officers to be asking those questions and informing you about it. But again, remember, as Christina said, THC and marijuana are still illegal drugs under federal law, controlled substances. So an employer can ask about them with greater freedom than with prescription drugs.
Yeah, and I would suggest that you think about these issues and address them in your drug testing policies and with your drug testing provider before they come up.
Yeah, good advice.
This is a good question. What is the status or the applicability of workers' comp laws for remote employees? What if an employee gets injured while at home working?
Yeah, there was a big issue about that a few years ago. I'm sure Christina remembers this too, where an employee was working at home, went out to get a box the employer had delivered him. It was snowing. He hadn't shoveled the sidewalk and he fell and hurt his back. And there was a whole controversy over whether or not that was a workers' comp injury. It depends on the state law. It depends on the policy. And that's why that great point that Christina mentioned about if you know your employees are moving around, you want to check in immediately with your workers' comp carrier and make sure you have coverage in that state. The carrier will also decide whether or not the activity, whether it's done at home or not, is work related.
Yeah, but it's possible, right? We were talking in the pandemic about this concept of someone sitting at their computer at home, standing up and tripping on a kid's toy, and that possibly be workers' comp. You probably don't know the final answer until that gets completely litigated. But yes, that becomes their functional workplace. And although I do think there was a rule by one of the agencies that an employer is not expected to go inspect people's homes if they're working at home. So that's good.
Yeah, and they also mentioned you don't have to put that yellow paint on the employees' stairs if they have a downstairs office. And
oh, good. I'll take that off of my home office. It's painted yellow all over.
Yeah, it's pretty fetching. You should leave it. I like it.
So for 78B4 518, how will that interact with other state laws that limit employer liability? For example, innkeepers' laws that limit an innkeeper liability for theft to $250.
Innkeeper theft to 250. Yeah, I'm not sure how those would interact exactly. I mean, that law is specifically about employers who employ people in specific industries with criminal records. Is that what we're talking about here? I think so. I'm sorry, I don't remember the exact name of the number of the statute. I'm not really sure how that would interact if those two conflict in some way, and if they're both state statutes, probably whichever one is more specific to the situation would probably trump the other one, is my guess. Do you have any thoughts, Mike?
Yeah, and with an innkeeper statute, it might be the guest who's bringing a claim.
Right.
So that statute would apply to them, whereas the employee or somebody else bringing a claim under the, laws Christina was talking about might be analyzed differently, but you may have situations where statutes become in conflict, and that's why we have really smart people like judges who are supposed to figure that out and tell us, right?
So here's another question that's completely over my head. Do you anticipate federal law change around the remote work issue of applying location of ER instead of EE? With more remote work, it seems more ER friendly in a Republican legislature.
Well, we have a federal system, right, where we have federal law, state law, local law, and that's not going to change soon, if I'm understanding the question right. So, I mean, I think we're in a world where, when I started employment law back when dinosaurs roamed the earth, it was mainly a federal law question that we would focus on with occasional state law issues. I think it's almost totally flipped now, where all the actions at the state laws and the local laws. Christina, do you have the same experience?
Yeah, well, first of all, is the Congress going to be able to pass any laws whatsoever? Probably not. So that's point number one. Point number two, like we have in the US, there's just this entrenched concept that states can do what they want and they can have their own system, and that we basically have 50 different systems. I think it's very problematic. And I think for employers, it's a complete nightmare. I think most employers would prefer that there was one system of rules across the country, one tax system. And, even if those rules were more favorable for employees, at least we would know what they were and there was only one set. I think that would be an ideal, and I think that would help the business community. I think it would help employees, but getting there is going to be so difficult, given the nature of our system.
The current system's an employment lawyers full employment act.
Right. Well, that's a good point. I guess it's good for that reason.
See what this says. Oh, thank you. And that's just what I was going to say. Thank you very much to the two of you for donating so much of your time to put this together. Tell Mark thanks. This was amazing. And I really think that this is one of those that people are going to watch over and over and over, and we'll have to have you back when something changes. So thank you very, very much. And I hope to see everyone again soon.
Thank you.
Good to hear.